my meeting?
16, thank you folks. Lovely. I'm sorry mate, what's your name again?
Paddy, P-A-D-D-Y.
Lovely, Paddy, thank you. Lovely, and nominee of Unit 15 is also present. And then on Zoom, we've got Dan Walker, which is lot 9, present on Zoom. And then who have we got there? Sorry, Susan. Lovely. Susan is from number 12. Lovely. Susan is on Zoom as well. Lovely. And then from folks, we've got voting papers from units 1, 2, 3, 4, 5, 6, 7, 8, 9. Nothing from 10. And then voting papers from 11, 12, 13, 14, 15, 16. So that's obviously a total of 15 lots represented, folks, which is indeed a quorum. And the meeting today can proceed, Mr. Chairman.
Thank you very much, Dan. So I'll be reading from a set of notes to keep things clean and clear. Good morning, everyone. I declare the extraordinary general meeting taking place open. Before we proceed, I want to remind all attendees that this meeting must be conducted in accordance with the Body Corporate and Community Management Act, the relevant regulation module, and the agenda circulated. Discussion must be combined with the motions before the meeting. Allegations about individuals, legal disputes, or matters outside the scope of the agenda are not appropriate for this forum and will not be entertained. The role of the chair is to ensure the meeting proceeds fairly, efficiently, and lawfully for all owners. I will intervene when necessary to maintain order and relevance. I ask that Dan keep count a tally of all voting for the records of the meeting. This is Dan McMahon from Alpha. Transparency. I wish to declare the relationship I have with Unit 15 for transparency. Unit 15 is owned by a trust. This is not owned by me. I have no financial interest. I am not the proprietor of the air conditioning business at the premises. This is a matter of record. I have very recently been engaged part-time to assist the business at that premises in a paid admin role. False claims have been made otherwise, and on several occasions. I have always been careful to manage possible or perceived conflicts. With that, we will proceed item by item. I'll move for confirmation of the minutes of the last general meeting. I'm after a seconder.
Wait, yep, a few hands going up there.
And those in favour?
From the voting papers, we have all in favour except for one abstention. So we have 14 votes in favour and one abstain, none against.
Okay, a bit of preliminary guidance before we move to the motions 2 and onwards. I want to emphasise the importance for members to submit votes prior to the meeting. Early lodging ensures that all members' intentions are formally recorded and considered in accordance with the CMS. It also helps the meeting run efficiently, even if motions are later ruled out of order. Any member may still challenge a chair's ruling of any motion being out of order during the meeting. If a majority supports that challenge, the motion may proceed to debate and then vote. Acknowledging objections. We've received objections from members regarding some motions, including concerns about the scope of bylaws, potential impacts on statutory rights and its intended purpose, specifically motion 2. As chair, I acknowledge these concerns. Members retain the right to challenge this motion after the meeting by lodging a Form 22 application with the Commissioner under the BCCM Act. I also remind all owners that nothing in any bylaw can override statutory rights. These include, but not are limited to, Section 205 requests for body corporate records, raising motions at general meetings, participation in dispute resolution processes, reporting non-compliance or safety concerns to relevant government agencies. All owners retain these rights regardless of the outcome of this vote. Regarding motion 2 specifically, communication by owners to be reasonable, I reviewed the motion and judge it to be in order. Discussion should focus on the content of the proposed bylaw, specifically how it regulates communications within the scheme, rather than personal commentary about any individual or past events. If legal questions arise regarding the validity or interpretation of this bylaw, These may be reviewed by the Commissioner or an adjudicator after the meeting. The purpose of this EGM is to consider and vote on the motion, which is as properly tabled. We'll now allow owners to speak on the motion. Please focus your comments on the bylaw itself and its intended purpose. Once discussion concludes, we'll proceed to vote in accordance with the notice requirements for special resolution. So I open the floor to discussion on the motion to add a new bylaw that communication by owners is to be reasonable.
No.
No
Discussion?
No further discussion, we move to a vote.
Move to a vote. From the voting papers received, we've got 14 votes in favour and 1 against. So the motion's resolved, Mr. Chair.
Thank you. Motion 3 proposes consent to record a new community management statement to restrict residential use of lots, exclusive use areas and common properties. After review, I judge this motion to be in order. We have received objections from members regarding potential impacts on owners' rights, scheme governance and public perception. As Chair, I acknowledge these concerns. Members who object retain the right to challenge this motion after the meeting by lodging a Form 22 application with the Commissioner under the VCCF Act. I remind all owners that nothing in this motion or the proposed bylaw can override statutory rights under the VCCF Act. As I've said before, owners retain all legal rights to submit Section 205 requests for body corporate records, raise motions at general meetings, participate in dispute resolution processes, and report safety, compliance or other concerns to relevant government agencies. All statutory rights remain intact, regardless of the outcome of this vote. I request that the discussion remain focused on the motion itself, specifically the proposed restriction on residential use and the effect it may have on the scheme and common property. Comments should not include personal allegations or disputes about individual members or committee conduct. If there are questions regarding the legality or enforceability of this motion, such matters may be considered by the Commissioner or an adjudicator after the meeting. The purpose of this EGM is to consider the motion as properly tabled and allow owners to vote. We'll now allow owners to speak on the motion. Please focus on the motion's purpose and effect, not personal disputes or allegations. Once discussion concludes, we'll proceed to the vote in accordance with the notice. Opening to the floor for discussion on the motion to restrict residential use.
No, doesn't appear to be anyone, Mr. Chair.
Go to vote.
We've got 14 votes for the motion, 1 against, so that motion's resolved as well.
Okay, moving to motion 4, common property car parking. After consideration, I rule motion 4 in order. I would like to provide some context and guidance for members before discussion. 1. Comparison to current parking practices. Jasmine Place currently operates under a shared parking etiquette framework in place since before 2023. This allows flexible and cooperative use of parking spaces, including short-term operational needs such as loading, unloading and vehicle manoeuvring. Under this framework, it is effectively possible for a lot to use more than one space temporarily for operational purposes without formal allocation. 2. Key changes introduced by the proposed bylaw. Each lot may now park only one vehicle, which may reduce the flexibility currently available under the shared parking etiquette. It prohibits shared unused spaces or permitting other owners to use your parking entitlement. The term bona fide visitors is included but not defined in the motion, which may create uncertainty about who may use unoccupied spaces. 3. Practical considerations. While the motion clarifies parking rights, it may restrict short-term operational use for legitimate business activities, including temporary use of additional spaces. Enforcement could be challenging, as the motion does not provide guidance on monitoring, dispute resolution or signage. No evidence has been provided to demonstrate that restrictions are necessary or that current cooperative practices are causing issues. 4. Impact on cooperative practices. The existing shared parking etiquette has successfully balanced operational flexibility and fairness. Introducing a formal one space per lot rule may reduce flexibility, create friction among owners, and increase community administration. 5. Summary. Members should weigh the benefits of formalising parking rights against potential operational limitations, ambiguity in visitor use, and enforcement challenges. One possible approach could be an amendment permitting limited short-term use of additional spaces for operational purposes while maintaining the unallocated status of parking. This overview provides context and consideration for members. I now open the floor for discussion on motion 4 regarding the parking motion. Please focus on practical implications, potential operational and enforcement issues, and impacts on cooperative and flexible use. Open the floor to discussion.
No discussion.
Move to vote.
We've got 1 vote for the motion, 14 votes against the motion, so that motion's lost. No abstentions.
Okay. Members, the motion regarding the incorporation of Sunshine Coast Council Development Approval Condition 5 into the Community Management Statement is a legitimate and enforceable motion. This is the motion regarding operating hours. This is because legal obligation. Condition 5 of the development approval explicitly requires that the approved operating hours be included in the CMS. This is not discretionary, it's a mandatory requirement imposed by Council. The motion provides precise wording for the bylaw limiting commercial operations to 7 a.m. to 6 p.m. Monday to Saturday with no operations on Sundays or public holidays. This is specific, clear and capable of being enforced by the body corporate. Relevant to scheme governance, incorporating this condition ensures the CMS is compliant with the development approval, allowing the body corporate to properly manage common property and reduce non-compliance risk. For these reasons, the motion is properly within the powers of the body corporate under the VCCM commercial module and must be considered by members. The meeting will now proceed to vote on this special resolution. Is there any discussion from the floor?
No.
The voting?
The voting, motion 5, got 1 vote against, 1 vote for the motion, apologies, 14 votes against the motion, no abstentions, motion's lost.
Okay, this is unauthorised transport depot operations, Unit 16. The explanatory notes associated with this motion seeks to direct the committee to take specific enforcement actions against the named owner and lessee. While the intention may be to address non-compliant activity, the motion as drafted is not legally permissible. Under the VCCM Act, members cannot compel the committee to take specific actions. Enforcement, compliance and risk management decisions are the committee's statutory discretion and must be exercised lawfully. As drafted, this motion firstly attempts to bind the committee to take specific enforcement actions against a particular owner or lessee. Second, contains personal allegations against a named lessee, which raises legal risks, including potential defamation or privacy breaches. Third, it directs the committee on how to act in matters that fall within their lawful discretion. And fourth, is consistent with prior rulings where similar motions, including assigning PCBU obligations or authorising commercial operations, were ruled out of order. Members may, for example, instead propose a motion requesting the committee review the operational use of Unit 16 or provide guidance or a report on compliance matters which would be in order. For these reasons, I rule motion 6 out of order as drafted. Members may, however, propose alternative narrowly defined motions that are compliant. Members have rights to propose motions. Any member who disagrees with this ruling may challenge it during the meeting. If the majority votes to overturn the ruling by the chair, the motion may proceed then to debate and vote. Members may also propose amendments to make the motion compliant and in order. Amendments must be relevant to the original motion, and if passed, the amended motion may then be voted on. For the record, motion 6 is ruled out of order as drafted. Members may challenge this ruling or propose amendments. Are there any challenges? Any discussion?
No.
So it's ruled out of order.
Ruled out of order.
7, prohibition of workplace activities on common property. Again, the explanatory notes for this motion indicate it seeks to prevent commercial operations on common property. While these concerns are acknowledged, the term commercial workplace activities is broad and lacks sufficient precision. It could capture routine operational tasks such as loading and unloading, or incidental activities such as answering work-related phone calls while in a vehicle, as well as more substantial activities like manufacturing or assembly. Bylaw 10.1b in our CMS already requires owners to use their lots in accordance with their approved purpose and to observe all CMS requirements. Limited and incidental operational use of common property is therefore already addressed. As drafted, this motion may conflict with existing bylaws and could create ambiguity in interpretation and enforcement, including potential work health and safety and compliance implications. In addition, routine and short duration activities such as loading and unloading are generally incidental to the approved commercial use of lots within the scheme. These activities are typically temporary in nature and form part of normal business operations, provided they do not result in obstruction, unsafe conditions, or ongoing storage on common property. For these reasons, the motion as drafted lacks sufficient clarity and certainty to be enforceable. For these reasons, I rule motion 7 out of order as drafted. And again, any member who disagrees with the ruling may challenge it during the meeting, and members may also propose amendments to make the motion compliant and in order. So, is there any challenge from the floor?
No.
Or discussion? So motion 7 is ruled out of order as drafted. Okay, we move to motion 8, authorisation of workplace activities on common property. The explanatory notes indicate this motion seeks to permit commercial operations on all common property and assumes associated compliance obligations, including PCBU and work health safety responsibilities on behalf of all owners. While the intent may be to provide clarity for commercial use, the motion, as drafted, is problematic. Under the BCCM Act and prior rulings, members cannot assign PCBU or statutory obligations by resolution or by law, nor can they authorise commercial operations in a way that overrides legislation or existing bylaws. As drafted, this motion attempts to override statutory compliance obligations, could impose legal and financial obligations to all owners, lacks clarity and could be interpreted to authorise unlawful activity, and contradicts prior rulings regarding similar motions at previous meetings. Members may instead propose a motion requesting the committee review operational use of common property and provide guidance or a report, which would be in order. For these reasons, I rule motion 8 out of order as drafted. Member writes, again, any member who disagrees with this ruling may challenge it during the meeting, and members may also propose amendments. Is there any challenge from the floor?
No.
No discussion or challenge? We continue to rule that motion out of order. Motion 8. Motion 9 is to agree that the written approval be given to Unit 10 regarding parking stops. I've reviewed the motion and I rule that it is in order. Members may now consider the motion and raise any discussion points, questions or proposed amendments. Key considerations: members should carefully consider the following before voting. Historically, the motion notes that the parking stops were already absent when Unit 10 was taken possession of. Practical implications: the absence of the stops facilitates loading and unloading activities, which is operationally practical for this unit. 3, safety and common property use. Members should consider whether the continued absence of the stops has any impact on vehicle safety, access, or use of common property by other owners. Consistency: approving the motion sets a precedent. The same consideration may need to be applied to other units if similar circumstances arise. 5, temporary versus permanent approval. This motion does not specify a time limit. Members may wish to clarify whether this approval is indefinite or subject to review, but it can be voted as is. Is there any discussion on that motion? Go to vote.
There we've got 14 votes for the motion, 1 against. Motion is resolved.
And finally, correspondence. Members, the body corporates received correspondence relevant to matters discussed at this meeting. As this is an extraordinary general meeting, no further motions can be considered. Correspondence will be noted and, where appropriate, referred to the committee for consideration or included in a future general meeting agenda if required. And that closes the points of discussion and agenda for our meeting.
Lovely.
Declare the meeting closed at?
And 10:55. No, sorry, 9:55. 9:55 a.m. Thank you very much. Meeting closed.